Welcome everyone to today's webinar, Changes to Welfare Fraud Prosecution. My name's Carly Hansen. I'm the Sector Development Officer at Community Legal Centres Queensland, and shortly I'll be introducing our presenter, Scarlett Wilcock. Firstly though, I'd like to acknowledge the traditional owners of the land on which we're holding this webinar. In Brisbane, they are the Turrbal and the Yagara peoples. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role that Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being watched by people throughout Queensland and probably throughout Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and welcome any First Australians who have tuned in to today's presentation. So today's webinar is being recorded and I've emailed out the PowerPoints this morning to you for everyone who registered as at about 10:30 this morning. If you didn't have a chance to pick them up, you can grab them from the handout section on the GoToWebinar control panel. So they're as a PDF document, but mirror the slides that Scarlett's presenting today. Today's webinar is about welfare fraud prosecution, which is a really important issue and something probably a bit of a hot topic on many people's minds following robo-debt and some of the other things that have been happening around Centrelink and Department of Human Services. So Scarlett's been doing some research on the decline. There's actually been a decline in the welfare fraud prosecution rate, which actually may come as really good news to many community legal centre workers and the people that they help. So Scarlett Wilcock is a lecturer at the University of Wollongong and a board member of Welfare Rights Centre, and she's going to talk about some of those reasons underpinning this trend and highlight the potential for sustained reform of welfare fraud prosecution strategies, including things like the effect of quantitative prosecution targets, changes to the pool of cases selected for prosecution, including a reduction in the proportion of women prosecuted for welfare fraud, which is interesting. Also, the uptake and development of an intelligence-led policing approach to fraud investigations and a changed culture among fraud investigators. So Scarlett's presentation today is delivered in partnership with the National Social Security Rights Network. Many of you may be aware of that network or part of it, so thank you very much for assisting with organising this today. So today we'll hold the questions over to the end of the presentation as we usually do, but feel free to type anything into the question box as we go through as you think of it, if you've got any comments or questions for Scarlett. Also, if you do have any technical issues as we move through today's presentation, please let me know either by email, and you should have that there from this morning's email, or by typing into the question box, and I'll see if I can address those. But without further ado, I might now hand over to Scarlett. So take it away, Scarlett, and I'll see you again at the end of the session.
Well, thanks so much for that introduction, and I'd also like to acknowledge the traditional owners, which is where I am today in Wollongong, is the Wadi Wadi people of the Darrell Nation. So as outlined very effectively there, I want to talk a little bit about some of my research findings on social security fraud investigation and prosecution strategies today. This research draws on a variety of data that I've collected and analysed over the last 4 years or so, including interviews with social security lawyers in the CLC sector and from legal aid across 3 states, as well as about 13 interviews with compliance staff from the Department of Human Services. For those of you that are currently working in this area of social security fraud or even administrative cases, some of these findings might not be news to you, but I really still hope this provides you with an opportunity to reflect on your work and to perhaps also reflect on some of the patterns and what they mean for the future. I'm really interested in continuing my research in this area, so I'm eager to seek information and input from lawyers. So I guess you can really take this webinar as part presentation, part invitation, and please feel free to contact me either today or into the future if you have any information, because often lawyers working in this area find out or identify emerging trends before anyone else. So today, what I want to do is just start with an overview of social security prosecutions, and then examine some of the reasons underpinning the high rates of prosecution in the 2000s, before examining what's changed. Then I want to pause to consider the relationship between women, gender and welfare fraud, and then look at some of the ongoing and the new problems and opportunities for reform. But first, let's have a look at some of the trends in social security prosecution in the long term. So this graph here presents data on the number of social security prosecutions completed each financial year since 1959 to 60. Yes, it did take forever to find this data. But as you can see, notwithstanding several peaks and troughs, the longitudinal trend has been upward. Then we see in this kind of field here in this point here in 2010 to 11, where prosecutions began to fall sharply from about 3,500 prosecutions in 2009 to 10 to a low of about 1,000 in 2014 to 15. At the same time, the social security recipient population increased. So as a rate of that population between 2010 and 2015, the prosecution rate actually fell by 80%. This is really significant, particularly since the national dialogue and the policy response continues to focus on a tough approach to welfare non-compliance and fraud. So how could the prosecution rate drop so significantly, and will it be sustained? And they're really the questions that have driven this research. So I just also wanted to have a quick look here at some of the offences for those that might not be familiar with this area of law. There's a suite of offences that capture behaviours that we might describe broadly as welfare fraud in the Social Security Administration Act and the Commonwealth Criminal Code, and some of these are listed here. But by far the most commonly prosecuted offence is the offence of obtaining financial advantage under the Criminal Code here, and it carries a penalty of 12 months imprisonment. Recently, the High Court has outlined the conduct and fault elements, or confirmed them, I guess, in the case of Poniatowska, and I'll return to this a little bit later. But basically, we've got the elements being that the defendant intentionally engages in conduct, and conduct explicitly includes an act or omission, of course, when there's a duty to act, that as a result of the conduct, the defendant obtains a financial advantage from another person, being aware of the substantial risk that this will occur, and having a regard to the circumstances that are known to him or her, it being unjustifiable to take the risk. And that the other person is a Commonwealth entity, which includes Centrelink, the Department of Human Services. So that's really that main offence that's charged and accounts for the vast majority of prosecutions. So let's turn then to prosecution in, prosecution in the 2000s. So this really, as that first graph showed, that prosecutions really increased in the 2000s, and they really stayed high in the 2000s. So at the time and until around 2009, Centrelink was an independent statutory authority responsible for the delivery of human services. So Centrelink, their service delivery operations were under this kind of purchaser provider framework, where policy departments like the Department of Family and Community Service and its various iterations would effectively contract with Centrelink to deliver specific human services. So there was that purchaser provider separation. Centrelink had a dedicated fraud investigation network, which comprised a decentralised network of 11 fraud investigation teams, or FITs, and these were located across capital cities and regional centres. FITs were responsible for detecting and investigating fraud and referring cases to the Commonwealth DPP, who was responsible for then deciding whether or not to prosecute them. The investigative process was governed by an array of policies and performance indicators and benchmarks, but there are two really here that are important to my research that I would argue really drove up that prosecution rate. The first was what we call automatic referrals. Basically, in the National Case Selection Guidelines, which have since been dispensed with or changed, I should say, basically what was required that all cases of social security welfare overpayments involving debts of $5,000 or more had to be considered for investigation, even if the initial raising of the debt didn't raise any allegation of fraud. So we're talking about accidental debts as well. So all of those debts that raised in any kind of way, whether it was data matching or whatever, were considered for prosecution if they were in excess of $5,000. So what Centrelink did to meet this requirement was it set up this automatic referral process with those debts were automatically referred for consideration for investigation, but they actually then did make up the bulk of the investigation load. The second benchmark or thing that drove up the prosecution rate was the quantitative KPIs. So these were contained in Centrelink's agreements with the policy departments, and basically they always from the beginning contained some kind of savings goal. But from about 2000, they also contained benchmarks about actual prosecution. So in 2000 to 2001 financial year, the agreement between Centrelink and VAX required Centrelink to refer 3,750 cases of suspected social security fraud involving VAX payments, which is the Department of Families and Community Services payments for prosecution. But what happened, so these were sort of Centrelink-wide goals, but to meet those goals, what happened was that Centrelink developed individual targets that apply to each single investigator. So in 2008 to 2009, all investigators employed at the APS 4 and 5 level had to complete 96 fraud investigations, refer at least 6 cases of suspected fraud to the Commonwealth DPP, and ensure that 85% of those cases were actionable by the DPP. When I spoke to investigators about Centrelink fraud prosecutions at the time, they told me it was really a numbers game, and the one that was very much driven by external targets and agreements. And here's one of the quotes from my interviews. As Oliver said, policy departments, which were then FAXIA and DUA, had responsibility for determining how we went about our compliance activity. So essentially, we just delivered what they said. And as another investigator said, policy departments used to tell us, you've got to do 5,000 investigations, you've got to do 1,500 prosecution referrals, and you've got to raise this much money. So we basically said, well, we'll find the 5,000 easiest cases. We don't have to prove much to the DPP to get them accepted, because all we have to do is a statement of facts. And that's a direct quote from a fraud investigator from the Department of Human Services. So if we can think about then the consequences of these, this decentralized network with these targets and benchmarks, basically what happened was, and perhaps unsurprisingly, that referrals to the Commonwealth DPP increased, but also what we see is reduced quality and reduced accountability. This graph on the right here shows the number of referrals to the CDPP compared to those cases that the DPP actually prosecuted. So what happened in that particular the case in the late 2000s was that more referrals were being rejected by the DPP, and the most common reason for rejection was insufficient evidence to prove the charge. So what we see is that's just one example or one piece of evidence to demonstrate the kind of declining quality of those investigations. But more importantly, I think, is that it really led Centrelink to focus on the least serious kinds of frauds, what you might call the low-hanging fruit. In fact, there's quite a bit of evidence to suggest that some serious cases actually involving sophisticated and premeditated fraud were dispensed with because they were too time-consuming to finalise, and it wouldn't enable the investigators to meet their targets. And I think one of the interviewees that I talked to captured the approach very effectively in these words. She said, like I said, we just used to prosecute. Quite frankly, it used to be about a number. It used to be about a benchmark. So what happened during this period was that prosecution emerged as the ultimate goal of fraud investigation, basically or almost in any circumstances. The number of prosecutions, rather than the merits or whatever else might be the measure, became the only marker of success. What's unfortunate about this approach is that this impacted the most severely on the most vulnerable in our community. And you can see this from some of the kinds of people that were targeted during this period. So in the peak of that prosecution first approach during the 2000s, we see that about 2 in 3 top cases were against women. that single mothers were significantly overrepresented, and we know single mothers on Social Security are some of the most vulnerable and experience some of the most severe economic disadvantage in the community. That most cases involved an under or misreporting of income, and this is what some researchers have described as those people stuck at the employment benefit nexus, so that kind of nexus between insecure casual work and seeking benefits. And we can see also there, which is the pie chart on the left, in 2008 to 9, basically the vast majority of people that were prosecuted were on parenting payment single and New Start. And those were really where the focuses lied in terms of detection and investigation. And again, New Start and PPS payments are often more vulnerable people on them. Sometimes, especially New Start, the rates are very low and people are likely to experience a range of disadvantage. The other finding that I think is interesting from other work done by Milestone and Walsh was that there's really not a great deal to distinguish low-level fraud cases with administrative debt cases, and both really were often characterised by confusion, poverty, and when I say confusion, I mean confusion about the complex reporting, especially complex income reporting processes and obligations, financial and other disadvantage, and administrative error as well. And so in those kinds of cases, there may not be that much to distinguish those debt cases from the low-level fraud. So what we see is those people that were prosecuted, the focus of those low complexity cases really did disproportionately impact the most disadvantaged members in the community. And it's here that I just want to pause here to think about this, the relationship between women, gender and welfare fraud. Basically, it's incredibly unusual for women to outnumber men in any crime category, and this applies even to those crimes that we might think of as more feminized or feminine crimes like shoplifting and fraud. So men still tend to outnumber women even in those crimes. So for women to outnumber men is unusual. It's quite an unusual phenomenon. And there's a wealth of literature from around the world, not just in Australia. This is something that's not just something experienced here, but that interview women, that look at statistics, that try and trace and track and examine the context of women's social security offending. And there's really three key themes that emerges from this literature. In an interesting way, these three things also apply to pretty much a lot of those people that are prosecuted for welfare fraud, but these three things are also themes and issues that are more common, that are much more common for women. So the first is poverty. So poverty in the context of welfare and labour market reform, and women are more likely to experience poverty, particularly single mothers. It was also precarious work and the complexity of managing welfare and all its rules and requirements and casual work and trying to make that work and comply, and also just trying to manage money between those systems. And thirdly, also having the added costs and imperatives and the feeling of obligation to children and again, women bearing the majority of caring responsibilities. So there's sort of the three key themes that underpin a lot of women's social security offending, from at least the literature suggests that's the case. What I think is interesting in Australia, I should just say here's the women's social security offending is characterised as a crime of survival. And I think it's interesting that actually one of the fraud investigators characterised it like that as well. She said something like, it's like a survival instinct for women. Like they've struggled for a number of years, whatever they've got, their kids, they give to their kids. A lot of time it will be that I need to look after my kids. And so this is somebody that investigates fraud. So this is quite interesting though, is that what we see in the height of what I would call the prosecution first era during that time in the 2000s, we see that the rate, or the numbers I should say, of social security prosecutions against women really spike, and then we see it really decline. So at that spike, it was about 2 in every 3 people were women that were getting prosecuted for welfare fraud, and then that's decreased. It's interesting, though, that women are still more likely to be prosecuted compared to men, but that proportion has really decreased. So the changes have worked in the sense of that vulnerable women are less likely to be prosecuted than they were, but they're still more likely to be prosecuted than men. So let's then look at what's changed. What's really changed since 2010 to 11 to make this drop occur? So there's the first thing, and you really just have to mention it because it was a significant factor at the time. Many of you are probably aware of this already. But the first was the effect of two high court cases, Poniatowska and Keating, on what we would call omission cases. And that refers to cases where the allegations of fraud relate to an omission, a failure to do something rather than a positive act, any positive act of, say, misrepresentation or dishonesty on the part of the recipient. So in Poniatowska, which was handed down in 2011, the High Court considered whether Ms. Poniatowska's failure to report her income could constitute that conduct element for the offence of attaining financial advantage, and said, well, no, because there was no positive duty to act in the legislation. Basically, as no obligation existed at law, no crime had occurred. And this really threw about 15,000 cases into doubt, according to the Legal Aid Victoria. Leading up to this decision, the government sought to preempt the decision by passing a law to create this positive obligation to report and applied this obligation retrospectively to the year 2000, I think. But basically that's Section 66A, which was inserted. But of course, then Keating came along and successfully challenged the retrospectivity of Section 66A. So the combined effect of these two cases was to prevent the department from prosecuting omission cases where the relevant omission had occurred prior to the 4th of August 2011 when Section 66A was inserted. So it sort of affected the pool of cases that could be prosecuted in the short term. And those omission matters historically accounted for a substantial proportion of referrals to the Commonwealth DPP. So it did impact that pool of cases. And as the Commonwealth DPP noted in 2013, in light of the Keating decision, we discontinued a number of prosecutions before the courts in accordance with the prosecution policy of the Commonwealth. But it also included, because the investigations that were underway, which were dropped and changed into administrative cases rather than criminal investigations. The second, there you go. That's my conclusion. It reduced the pool of possible cases in the short term. The second change, which is another administrative shift or policy change that impacted on the prosecution rate, again in the short term, is the changing responsibility for who had to prepare briefs of evidence. So formerly, Centrelink wasn't required to provide a formal brief of evidence, just a short form brief, which was little more than a statement of facts. And as one investigator told me, ordinarily usually it would have been less than a 1 page. It's usually just half a page. And then what happened was that the Commonwealth DPP would prepare the full brief of evidence. But from November 2011, the Commonwealth DPP required the department to prepare briefs of evidence. And this involves collecting all the evidence that you would present if it went to trial, and is much more time consuming and requires specific knowledge of the criminal process and evidentiary rules. And Peter, one of my people that I interviewed, he said in the past, when we were doing large numbers of the referrals to the DPP, they allowed us to do a short form brief, which wasn't much more than a statement of facts. And they would actually take the case on that basis. 99% of our cases were uncontested. People would plead guilty, and that would be the end of it. So on that basis, it wasn't such a workload issue for the department, and really the CDPP took that role on. But when that shifted, what happened was all of a sudden the department's workload increased, and that really impacted on the volume of cases that they could pursue. So as another person told me from the department, in terms of volume of work and change for the investigation teams, that was a major change. And they said it was as influential as the Poniatowska and Keating cases in terms of reducing the amount of cases that could be referred for possible prosecution. But listen, I think those two changes are important, but they don't explain the full extent of that drop. An 80% drop is really significant. And what I think is something more happened, and that really follows the audit by the Australian National Audit Office and a range of reforms that were undertaken internally rather than at the national policy level. So what we see is that there's the quantity prosecution KPIs were scrapped. That threshold amount for automatic debt referrals, they still do that, but the debt amount was increased to $10,000, so doubled. They introduced what we call an intelligence-led model of policing, which is really just I guess, this kind of model based on advanced data surveillance. And so what you see is a real appeal by the business integrity and Centrelink overall in this kind of appeal to advanced data surveillance, including data mining and all this kind of jazz. So the idea is being it's more sophisticated, it's much more data focused, and that will be able to find more selections, that is cases to have a look at, which will better select the more serious cases. There was an explicit focus on the more serious cases, and there was a real attempt to try to stop or the ones that those frauds that were more serious and more sophisticated that were sort of fell by the wayside to make those a priority. So they established a serious and complicated fraud project and a whole range of things to try and make sure that that was the focus. Whether that worked is debatable, and certainly sometimes what would happen is that in those serious and complex fraud teams, they would also put member of a couple cases, and some of you who are working in those areas would realise that, yeah, sure, determining whether someone is a member of a couple is complex, but it doesn't mean there's a sophisticated fraud underfoot. So whether it's complex rules or complex fraud is a different issue. There was also much more increased centralisation and oversight and a new case selection matrix. And I just want to show you one part of that case selection matrix. So the case selection matrix is kind of the kind of key tool that is used to determine whether something should be investigated and referred for prosecution. And what this does is it basically has, it's like a quantitative list. So things like factors get a quantitative score, and then those factors go together, and then you determine whether something should be prosecuted. They were changed a little bit. So they had a similar one before, but this new one is more focused on serious fraud. But I'll come back to it a little bit about what might be some of the problems with that. But overall, I did really, in my interviews and in the way that things were changing, I really did discern a kind of less punitive culture. Certainly, it was still punitive, and I'm under no illusions that there wasn't a punitive culture still. But what happened was it was a real attempt by staff to say, well, we do actually want to be more accountable. We do actually want to go after the more serious cases. And really, I think some of these quotes capture it. Here's one from one fraud investigator who says, benchmarks are not what pushes us now. We look at the individual cases and we consider what we're doing, and we consider the impacts of what we're doing as well. If there's mitigating circumstances, we take them into account. For example, if someone has literary issues or mental health issues, we consider how this impacts on their ability to comply. So it was interesting to me, including another investigator who just said we still prosecute too many people, and that there was actually a critique amongst staff about the process for prosecuting people based on these quantitative targets from before. So I did discern a little bit of a lesser punitive culture emerge. Whether that's still around and whether that will stay is a different question. So that's an opportune time to turn to some of the familiar problems or enduring problems and some emerging issues in this new regime that we have. So what happened was after the Poniatowska and Keenan cases is that all emission cases were dropped. This also helped propel this focus on more serious cases because you couldn't just go for the straightforward admission cases. But some of my initial findings that are very recent suggest that there may have just been a return to admission cases and that they're coming back in, that kind of run-of-the-mill cases might be returning. Another thing that I think is interesting, and I'm not exactly sure what it means so far, is that in the last 6 months, all those people that, including the people that really led and pushed that, those, I'm supposed to say positive internal reforms rather than international reforms, have left the department. And what's occurred in there is that rather junior people have been promoted quite quickly. Morale seems to be very low, and of course this is based on anecdotal evidence from people that I know inside there now, and that a lot of people are leaving. So it remains to be seen what this means for the process, and whether this will just mean that things continue on as they are, or that they go back to what they were during the kind of Centrelink prosecution first period. Another issue is that a lot of lawyers have identified for me is the poor quality of the briefs of evidence prepared by Centrelink, the Department of Human Services. So what they're suggesting is that there's a whole bunch of stuff in those briefs that would actually be inadmissible, and that they're really not put together in the way that they should be. And that really raises issues, particularly because of the limitations on legal aid funding and a whole range of other things, which may mean there's quite a lot of people that could self-represent in this space. But also just it's a problem in terms of, good legal practice. And so this is the issue with letting bureaucrats take on what is quite a technical legal role. And there seems to be some moves to train up people in the department, but I'm still hearing from a lot of people that there's really poor quality briefs of evidence. The centralisation overall has really increased accountability, and all these decisions about whether to prosecute, whether to refer for prosecution, or whether to launch an investigation properly, or whether to dismiss the case, etc., is all dealt with by a central committee. But what I've heard is that might reduce the ability for lawyers to argue for their individual client, and to sort of, there's that discretion is gone to be lenient in individual cases in that space. One of the big issues with that case selection matrix that I identified, that I was discussing earlier, is that one of the factors that is considered is whether someone's had a welfare overpayment before. And that is really concerning, because having a debt in the past doesn't mean that that person has any kind of, that they've committed a crime before, but just that they've got a debt. It might have been in an accident. It might have been for an administrative error bound up in other omissions or accidents on the part of the client. And that's really concerning, because it's quite easy to get a debt, and it's quite easy to get a big one, especially if your life's a bit chaotic and your work history is sporadic, and for a whole range of other reasons, that it's actually relatively easy to get a debt, and we don't really want, it's not really an appropriate indicator of the seriousness of if there's a debt now, about whether or not that should be investigated. And we still see we still see vulnerable people being targeted by prosecutions. So here's a little bit more about the case selection matrix, which is the activity assessment table, and we can't get access to this because it's excluded from the kind of FOI requests. But I found out a little bit about it through officials, and basically, according to one official, it says the activity assessment table looks at things like if the case is affecting the reputation of the department, how much the monetary value of the fraud is, how long it's been going on for. He said there's about at least 6 or 8 different factors, and there's a family of points for each of those, and basically a threshold that's set. And he continues on, he says, let's assume the bar is 100 points. So say in the claim, the fraud's been running for 10 years, you get a certain value of points for that. And what the value of the debt is, you get a certain value of points for that. If it's going to affect the department, was it deliberate, whatever those things are, and if it reaches more than 100 points, then it gets treated as a criminal investigation. If it doesn't reach that 100-point bar, then it just gets treated as an administrative review. So there's the activity assessment table that determines whether it's, I guess, serious or not quite so serious. the interesting thing for lawyers is that this kind of method of quantitative scoring doesn't really sit that well with individualised notions of justice. This activity assessment table has in many ways enabled the prosecution rate to go down. It has enabled the focus on more serious cases, but maybe it's not really appropriate in the way it works. If factors do in fact include reputational harm to the department, is that really an appropriate basis upon which to determine if a fraud is serious? It might not actually tell us much about criminal culpability and liability. So there is a real disjunct here with this kind of idea of quantitative scores, which at least creates some kind of consistency and accountability that may have been lacking before, but might create a whole new set of problems about what's labelled as serious and why in terms of fraud cases. And really, if we wanted to look at seriousness, we should look at the level of sophistication and premeditation of the fraud and the level of culpability of the individual. And that should be an individualised decision. So that's one of the key issues that's ongoing. And also, I would say, if we've got this particular system, it's not really a good protection if there is another push to become more punitive, because it will still let the most vulnerable people get targeted. It's not going to protect them under this system. And what we see is a bit of a push. We do see a bit of a push, and I think even a push back to quantitative performance indicators. And you can see this with the introduction and the work of Task Force Integrity. So it was set up in 2015 as part of that budget announcement, and is funded to operate until 2019, but who knows whether it will be made permanent. It's just lost its assistant commissioner from the AFP, but still works as a partnership between the Department of Human Services and the AFP, and has the budget to have 100 full-time staff equivalent. The last time I looked, it had 80 positions filled, so it's quite significant. But what I think is interesting is the work that Task Force Integrity has done, which really harks back to the kind of Centrelink days of the 2000s, which was all about numbers, how many reviews have been undertaken, how many suspected cases of fraud, and also about numbers, figures, and things that are very much about what can go to the media. And you can see that where some of the kind of pushback and criticism of Task Force Integrity when it was doing those operations in those apparently high-risk neighbourhoods, which would go in there and send everybody a letter which had the AFP logo on, saying, you know, we're looking for fraud in your area. And some criticism suggested it was a bit of scare tactics and inappropriate, and treating the social security population as if they were suspicious. And this really does look to me like a return of some of the ways of the past, which is a prosecution first mentality. So I guess what part of what we can see here is that, yes, there have been really significant changes. An 80% drop in the prosecution rate is significant, and it is cause for hope for community legal centres and others working with people on welfare. But at the same time, this is not a done deal, and certainly people that are vulnerable and people that shouldn't be prosecuted continue to be prosecuted. And some of these issues are happening in certain places. So we see some of the childcare related investigations, which seem to be targeting the African community. And what that's one of the strategies they're using there is network analysis. But what it looks like to me is that would just to connect people that are families or, you know, other relationships, and that again may not be an appropriate basis for suspicion, rather than looking at individual cases. So again, this idea of this sophisticated technology may not be the most appropriate basis for detecting cases and launching investigations. So we've got something significant and positive, but I think that what will happen, and already we're seeing that with the last figures with the prosecution rate, that it might go up again. So I guess what's the next thing is, well, what do we do? I'm certainly only just started this conversation. I'm interested in continuing it. I think in terms of legal practice, I think that there's got to be a little bit of sharing of strategies and seeing what each other's doing. And I think that it may, especially because the way that debts are being used as one of those factors. Past debts is a factor that to determine whether the investigation should be pursued and prosecution referred. Then we have to think about how debts are labelled and whether we can get them labelled in a different way, because what it appears to me that's occurring, and those people that are still working in this area, I'd love to hear from you, is that if the debt is characterised as an evaluation as part of serious non-compliance as opposed to just a compliance debt, then that is the particular debt that's being used in those factors. So if there's some way of moving the debt into the compliance zone, then maybe we can reduce the risk to that client. If you don't know what I'm talking about, it's a very precise, specific thing that occurs here in the Social Security investigation space. There is a lot of room, I think, to contest, but of course that requires good legal representation and resources, which we don't necessarily have. The guilty plea rate is still incredibly high. I think that on the last figures it was about 98%, and some of those cases I think probably could be contested rather than a plea of guilty entered. But that is a tricky one, and I mean, it may not necessarily, you know, it's obviously about the individual case and that client. As I said before, I think there might be some scope to share some strategies and maybe share some work. And I did put this one up here, self-representation resource, but I always worry with these, particularly if there's a possible prison sentence involved, of whether that might be just too risky. But interested to see what resources people have, if they have any. This is just because some of the legal aid, state legal aid funding won't represent people if they want to plead not guilty in this area, only if they're pleading guilty. What that means is they do want to contest it. There's not really many options for representation, but for private representation, or if that legal welfare rights organisation also does some prosecution work, which I know in New South Wales it does not. I guess in terms of policy and law reform, I have little faith in the current regime of government and the departments to really push for significant policy reform in this area. But what I do think is possible is much more targeted internal pressure, and that seems to be how some of these changes occurred. It was a couple of leaders and a couple of people really pushing back against that process and the prosecution strategies in Centrelink in the 2000s. So there might be some scope there. I think that we should have a look at that case selection matrix and perhaps seek changes to that. And maybe it could even just be about, you know, some factors that are about recognising the impact of prostitution on children, or changing the way that past debt is considered as a factor and weighted in that table. And I think this idea that all we need to do is increase the kind of intelligence-led processes and the kind of network analysis and hotspot mapping that's become the kind of in vogue way of doing fraud investigations. Some of these things really are discriminatory. They hide what looks like a very neutral and objective and technical and sophisticated process is actually hiding discrimination. And I've written a little bit about this and how single motherhood has been identified as a risk and what that means. So certainly that's something that can be challenged. And certainly, I guess I'll just, where's my, whoops. I will say that this is certainly an area that I'm interested in continuing to work on. Part of my work, I hope, would be about monitoring what happens with the prosecution rate. I'm also looking into some of the sentencing practices, and I'm just about to start a project with the National Social Security Rights Network on the relationship between social security compliance rules and domestic violence. I'm interested in needs, ideas, strategies, and really making sure my research is relevant and useful and seeks input from the CLC sector. So if you've got anything to please let me know, and my email address is up there, or you can ask me a question now. So thanks so much, and I will hand it back over and invite questions.
Thanks, Scarlett. That was fabulous, and it's really interesting to see those trends in the prosecution of people across such a long term, which is, yeah, it's really good to see, and obviously took a lot of research. So I will, I'm just going to remind everyone how to ask questions. Most of you probably are aware, but just for those who aren't new, you can ask your question by typing it into the question box on your GoToWebinar control panel, and I'll read those ones out so that everyone else can hear. Alternatively, if you do have a microphone and you'd like to ask your question verbally, you can do that by pressing the hand button and we can unmute you. So a few questions came through while you were speaking, Scarlett, so I'll just go to those now. So Evelyn's mentioned that you said that women were 2/3 of convictions. What proportion of welfare recipients were women? So I guess she's trying to ask, were women 2/3 of the welfare recipients? Is 2/3 proportionate?
Yeah, so the number of women that are on Social Security on the most recent figures I had is about 59 to 60%. So when they were 2 and 3, that was an overrepresentation of women. Now that proportion is roughly the same. So if you look at now that women still outnumber men, but it's about the same. So it's about 60% of the prosecutions are against women, and about 60% of the welfare population is women as well. So it's roughly proportionate to that population now.
Good to know. Mark's got a couple of questions here, or actually more comments, so I might just read that out. So I think this is when you were talking about the way that they were sort of tallying up points, but sort of around what kind of fraud, the amount, and how long it's gone on for, and talking about notions of justice. And Mark has said individualized notions of justice. Justice is notional and jurisprudential. Law is a process, a heartless machine. So that's very interesting to hear those comments, Mark. Sure many lawyers might agree with that as well. Scott, Scott's asked whether you've got any statistics on Indigenous women, so of course another very vulnerable group.
Yeah, I mean, that's a great question. I can't get aggregated data. So what I do know, and I can't get, I've got a data request underway that hasn't been, is being ignored at the moment. So I have to keep sort of following it up because it kind of sits outside, because it's not a single document, it sits outside some of the FOI rules. So it's a bit tricky to get. And I think I'm kind of not the favourite anymore in the DHS after they've seen all my research. But actually, this is from the Commonwealth DPP. So what we know is that Indigenous people are more likely to be prosecuted. I mean, not more likely, I should say, are disproportionately prosecuted, and that should come as no surprise to anyone on the phone line. We know that Aboriginal people and Torres Strait Islander people are overrepresented in all stages of the criminal justice process. From memory, the last one I found was that it was about 9%. In 1 year, it was 9% of the prosecutions were against people of Indigenous background, but only about 4% of the Social Security population are Indigenous or identify as Indigenous. I can't get data on the number of Indigenous women that are prosecuted, but I suspect it's higher. So I'm not sure, and I have been trying to access that, and that is something on my list of things that I'm interested in finding out. Certainly, anecdotally, I would say that that there is evidence to say that that's something that impacts Aboriginal women in particular.
All right. I think we'd be really interested in seeing that research if you ever do get your hands on that data, Scarlett.
Yeah.
So just a last call for questions. That's everything that I've got here, but if you do want to ask a question of Scarlett, this is a great opportunity to do so. If you want to have a bit more of a think about it and perhaps be involved ongoingly with her research and some of the future research projects that come up in this area, please do feel free to email Scarlett. Her email address is on the screen there. And I think we've just got someone who has a few questions here but isn't sure if she would like to email them or not. So she's sent through one. It's quite lengthy. Scarlett, are you happy to answer questions now, or do you want these to come through by email?
Why don't you read it out? And if I think I might need half an hour, I'll say thank you very much, and I'll respond by email.
All right, Evelyn, I'll read out your first question. So, Scarlett, how does the Integrity Task Force work with the serious non-compliance team? How much information do they have access to? And do they work on a referral basis, or do they choose what cases they pursue?
Listen, I'm not sure how much I know about that. So what I found, I'll tell you what I found out, and there's certainly some gaps in there. So it's a partnership, so they're actually based within the department, so they do have access to whatever they want. Most of those employees are actually DHS officials, and I don't know how it works. I don't know if they're seconded to that project or if they've also done external hiring. I suspect it's a bit of both. And this is just because I haven't looked at this in greater detail. Again, it's one of those things that's emerging. So what they do, as far as I understand it, is that there is some kind of they sit outside of the business integrity space. So they actually, I had to double check the most recent organisational chart, but it was like they were almost separate and had their own kind of leadership. I think that they're not that separate in practice, but in terms of on the organisational chart, they were separated, which might suggest that they've got independent decision making, or at least can sort of make their own kind of determine their own agenda. What they do is, I think what they can do is generate their own work, and that can be in conjunction or disconnected from serious non-compliance. But certainly on my list of things to find more about, and I've got a little bit more information, but I'd have to kind of sift through it. So I might take the rest of that on notice, if you like.
Excellent. There are a couple more that are here. So I might, because we've got everyone in the room together, the online room, I should say, it's probably useful for everyone else to hear these questions. And again, if it's something that you need to respond to by email, we can arrange that as well. So sure. Noting that the funding cuts for the DPP required Centrelink to have more legal knowledge to prepare prosecution briefs, did the serious non-compliance team get any training to address this? Again, it might be outside of the scope of your knowledge.
I know that they had some training, but I don't think that they definitely had training, and the DPP sent people over there to train them. And they've done that a few times because apparently that, their briefs haven't always been good. Even when they were short form, they weren't what they were supposed to be. So they did have some DPP people go over and sit in the DHS for a little while. I don't know what's happened since. That was a couple of years ago. So I'm not sure if they've got any more training since then or what's happened, but I suspect they probably would have to do something because I suspect the DPP wouldn't like it either. But, DPP is under extreme pressure right now, so in terms of its budget and what have you. So, yeah, I'm not sure.
Okay, not a problem. The last question there that she sent through is around whether you are aware of why there was sort of a bit of an exodus of staff from the DHS. So was it retirement impact or a cultural issue? So why is the personnel turnover high? I
don't know. Yeah, I don't know, and I would really like to know, but I can't really, I mean, no one will tell me. So I suspect it's a range of things, but I think it's no coincidence that everybody left at once. So it was so even the people, because part of this research was before my PhD research, and I needed approval on all my chapters, and often that was a bit of a fight. And so this was last year, and then all of a sudden I had all the people that were responsible for reading over my chapters. 3 of them left all at once, apparently for different reasons. But I think that's too much of a coincidence. I wonder if it was, so there was one leader that kind of, the national manager that was responsible for some of these changes, and interviewers spoke highly of him. He actually got a promotion at the kind of, the Dutton's mega department, and which I think is telling that you can go straight from the welfare bureaucracy to the Homeland Security department. But he went there, and so I wonder if other people left because they liked his leadership style and then that changed. So I'm not sure. I can only speculate, but I think that something happened, and I know that morale is low. That's the intel that I've got anyway.
That's great. I think obviously we can only speculate in those kinds of cases, having not worked there, but hopefully that answers your questions, Evelyn. there's one more from Jonathan. I hope you don't mind. We'll go through that. So he's mentioned that at the moment it looks like the Commonwealth are only detecting about 2.3 million of overpayments, whereas the Commonwealth is or will be spending double that amount each year to try and recover those overpayments. So he's wondering what the justification is or the reasoning for that kind of overspending. And obviously these types of debt recovery cases only sort of increase anxiety and other pressures for the people that they're who are the subject of them.
I mean, absolutely. It's interesting when money means so much, and so in politics it's always about what things cost, but in this space it's not so relevant. We seem to be able to spend all the money in the world to stop people getting money. I mean, it doesn't make sense, but yet those economic arguments don't seem to hold as much sway here. And I think part of it is, and this is, I guess, the theorist in me, but I think part of it is that there's a real outrage attached to welfare fraud and welfare cheats, and it's kind of whatever the cost, you've got to get them. And so that really drives this, the kind of policy and the spending in this space. And it's the kind of thing that, all major parties of all political stripes have pursued and seems to get a great deal of attention. It has been something and support, and has been something that's occurred elsewhere as well. And we talk about it as the redistribution of the welfare state away from actually assisting people and towards compliance. So we're still spending the same, we're just not giving it to recipients, where we're using it to, to actually institute all these controls. And you can see that also with the way that income management works. So the way that the kind of, cashless welfare card and all that kind of stuff per person, the cost of that is extraordinary. And it seems ridiculous that that's the thing that's been introduced to reduce other people's apparent misspending. And you think that perhaps what is needed is service delivery and this and that, especially when we're talking about remote and regional places. But that argument doesn't seem to come up. So it doesn't seem to make sense, but it's something.
I think we might have lost Scarlett then. Hopefully she'll come back on, but just in case she doesn't, I'm just going to double check that everyone else out there can hear. Just pop your hands up if you can still hear us, or if we've lost sound altogether. All right, great. So something's happened on Scarlett's end. I think we'll probably wrap up then in that case. So I'd like to thank Scarlett for presenting today, and thank you everyone for contributing all of those excellent questions. If you do have any further questions for Scarlett or wish to make any further comments, please do email her at scarlettw@uow.edu.au. The details are up on the screen. I'd also like to remind you to please fill out your feedbacks on the SurveyMonkey that will be sent out when the recording goes out as well. That would be really great, and hopefully Scarlett, you can hear us, and on behalf of everyone who's tuned in today, thank you so much for coming in and talking to us. Cheers.